We are recording.
All right, thank you. Good afternoon, everyone. The Appellate Court for the State of Connecticut is now back in session. We will now hear the matter of JPMORGAN Chase Bank versus MALICK, docket number AC 43262. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Alexander and Judge Bishop. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances, let me remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded not to disclose such information during argument. I would now ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall.
Judge Alexander.
I'm Judge Bishop.
All right, and counsel for the appellant.
Roy Moss for the appellant.
Good afternoon, Your Honors. For the appellee, Attorney Brian Rich.
All right, counsel, prior to this argument, you should have received procedural instructions. Do you have any questions regarding those instructions?
No, Your Honor.
No, Your Honor.
All right, a few additional preliminaries. When you are not speaking, if you would please silence your microphone while leaving your video on. We want to be sure that we don't lose anyone. Also, let me state the obvious. When you are not speaking, please try to comport yourself as though you were in the physical courtroom, so as not to create any distractions for the judges or opposing counsel. Each side will be permitted 20 minutes of argument. I will endeavor to give you a 2-minute and 1-minute warning. The appellant may, of course, reserve a portion of the 20 minutes for rebuttal. So, counsel, are you ready to proceed?
The appellant is ready.
All right, you may proceed. Let me know if you wish to reserve any time.
I wish to reserve the maximum allowable time for rebuttal.
All right, well, there's no rule subscribing that, but if you wish to reserve 10 minutes, that's fine with me. But you just indicate a time and we'll proceed from there.
10 minutes, Your Honor.
All right. All right, Attorney Moss, go ahead.
The issue on this appeal is whether the trial court erred in admitting and accepting as proof of debt in a foreclosure case an affidavit of debt filed by the plaintiff. And in turn, in order to determine whether or not the trial court erred, this court, under a standard of plenary review, must simply determine whether or not the amount of debt claimed by the plaintiff was in dispute. And there is ample evidence in the record that the amount of debt was in dispute. The debt may be disputed in the pleadings. And if it is disputed in the pleadings, then Practice Book Section 2318A does not apply, and an affidavit of debt is mere hearsay, which would be excluded, which must be, in that instance, excluded. In this case, the amount of debt was disputed in the pleadings. With respect to any allegation in the complaint, the defendant's answer, any allegation in the complaint relating to a balance due, the answer denied such allegations. I believe that's shown in response in the answer to paragraph 6 and 7 of the complaint. It's noteworthy that, of course, there's no particular amount of debt alleged in the complaint. There are merely references to a balance due, and that the defendant, who was self-represented, denied such allegations. That alone was sufficient for the trial court to bar, and that eliminated the applicability of 2318A. And for that reason alone, the dispute evident in the pleadings the plaintiff's affidavit or affidavits of debt should have been excluded. It's also true that it's obvious in the record and transcripts that the trial court relied on nothing other than the affidavits of debt or affidavit of debt that should have been excluded. Her finding as to the debt matched the affidavit of debt filed by the plaintiff. This court, I believe,
Let me interrupt you with a question. Did Mr. Malick present to the court any evidence to support any defense as to the amount of the mortgage debt that was averred to in the affidavit of debt?
Yes, he did.
And
for example,
can you speak to that, please?
Yes, for example, refer Your Honor to appendix page 37, which is an objection to affidavits of debt. That's number 149 in the trial court docket. In that, he filed that 3 days before the hearing on plaintiff's motion for judgment of strict foreclosure. And in that filing, he objected to the admission of affidavits of debt, and there, I think, had been 4 filed by the plaintiff up to that point. And in that, he said that he states that one of the components in the affidavit of debt alleged in the affidavit of debt was property inspection expenses or property inspection fees. And in that, I believe it's on the second page of that filing, he said he resides on the premises, the subject premises, full time, and there were no property inspections done. He had that evidence. Furthermore, on July 12th, he filed another memorandum in which he set forth the records from the town of Fairfield tax collector, which he submitted to dispute the amount of escrow payments or escrow deficiencies for tax escrow. That was one element of the debt set forth in the plaintiff's affidavits of debt. And that, I mean, that's clearly evidence. It's of substance. I'm not sure that it was sworn to evidence, but it's clearly something of substance that he was submitting with respect to the tax payments. That's something that's public record and could easily be determined, and therefore a very reliable submission that the defendant made. And that alone, okay, so if we get past the dispute that's evident in the pleadings, that submission alone shows simply that there was a dispute as to the amount of the debt. I mean, the defendant vigorously disputed the debt. Self-represented, yes. Somewhat clumsy, yes. That's evident in the record. It's evident in the transcripts of the hearings that took place July 5th and July 15th, 2019. But there was clearly a dispute. And at that point, the inquiry ends. The debt affidavit should have been excluded. Instead, the court in the July 12th hearing actually states that the court made all the findings as to the debt in the July 8th hearing. I may have said misspoken if I said July 5th. Hearings were held on the motion for judgment of strict foreclosure on July 8th, 2019 and July 15th, 2019. In the July 5th hearing, the defendant objected to the admission of debts. He explained he disputed the debt. He disputed the debt on various grounds, including those grounds for which I've stated that he submitted actual evidence. He submitted evidence regarding, ultimately, regarding a discrepancy of over $4,000 on the claims for an escrow deficiency in the plaintiff's affidavit, and as well as the claim for property attack or property inspection, but he also disputed the interest and said that he believed that for a period of time, the interest rate was under 3%. He used a figure of 2 point something percent, and that he thought that although he could not give a precise figure, he claimed that the plaintiff was not cooperating in giving him interest rate information because it was a variable rate note. But he estimated that the debt by way of interest component alone was $30,000 less than the roughly $235,000 of interest claimed in the affidavit. I mean, if these items are not genuine items of dispute, then the hearsay rule really becomes a dead letter. The transcript of the July 15th, both transcripts, 8th and 15th of July 2019, are very illuminating on these issues. Going forward, though, to the July 15th hearing, the court states that it had already made findings as to the amount of the debt. It put the cart before the horse. It was basically pitting the defendant's challenge to elements in the affidavit against the affidavit itself. That's putting the cart before the horse. There was a threshold issue here that the court never addressed, and that is the hearsay issue and whether or not 2318A applies. All the court had to do was determine whether or not a dispute existed as to the amount of the debt. And there was a good faith dispute initially raised in the pleadings. That was sufficient to bar an affidavit. And then there were his submissions and his statements at these hearings. And also another, in connection with this error, the error is really compounded by the court entering strict foreclosure law days while inviting the defendant, allowing him 2 weeks after the entry of judgment to possibly come up with more information regarding the debt. That's improper, to have law days and a finding of debt, and the finding of debt matched the plaintiff's affidavit. And that's basically the court explicitly, transcript page 24, July 15, 2019, holds the defendant to a standard of producing clear and unequivocal proof to contradict the affidavit of debt. That's page 24 on the July 15th transcript. That is error as a matter of law. And for that reason, this should be remanded for an true evidentiary hearing on the debt claimed by the plaintiff. Thank you.
All right, Attorney Rich, you may proceed.
Thank you, Your Honor. May it please the court, I am Attorney Brian Rich. I represent the appellee, JPMORGAN Chase, in this case. I want to start, Your Honors, with what appears to be a dispute between the parties as to what the proper standard of review here is. Attorney Moss made reference to this being a case of plenary review. I would invite the court's attention to Attorney Moss's appellate brief, where he recites the standard, the appropriate standards for plenary review versus abuse of discretion review. Plenary review, of course, involves where the court draws conclusions of law, whereas a trial court or an appellant's challenge to a trial court's evidentiary rulings are viewed under an abuse of discretion standard. This clearly was, to the extent, or at least insofar as I understand this appeal, the appellant's challenge is based on the trial court's acceptance or admission of the affidavit of debt by the plaintiff in the foreclosure action, which would invite the abuse of discretion standard. However, I don't want to go too far down this road because under either standard, I believe that this appeal simply is not viable. And that's because I just want to recite a little bit of the procedural history that I think Attorney Moss may have inadvertently mischaracterized. Your honors might be familiar with the fact that the trial court first entered summary judgment as to liability in this case. And after entering an order of summary judgment, which I believe was unopposed, or at least not timely opposed by Mr. Malick, the court then, in response to a motion for judgment of strict foreclosure by the plaintiff, set a hearing date of July 8th, 2019. And just prior to that hearing date, Mr. Malick, then self-represented, appeared before the court and indicated that he had some objection to the amount of the debt that was sought by the plaintiff. And in response, Judge Bruno, rather than simply discounting the unsubstantiated claims that he was making challenging the plaintiff's debt, invited Mr. Malick to have essentially 1 week's time to come back to the trial court with authenticated evidence as to why the plaintiff's affidavit of debt was incorrect in any way, in essence. And Mr. Malick simply failed to do that. He failed to comply with the trial court's directive, suggestion. I'm not sure exactly what the best word to call it is, but the trial court's maybe invitation that he provide, again, authenticated evidence challenging the plaintiff's debt. Instead, Mr. Malick filed a pleading that was referenced by Attorney Moss, which in unsubstantiated fashion simply said, I disagree with the debt being claimed by the plaintiff. There were no authenticated records attached to that objection from Mr. Malick from the town of Fairfield, to be clear. The pleading that was filed by Mr. Malick is a pleading signed by him that does not contain any admissible evidence that challenged the debt sought by the plaintiff in this case in any way. So what we have here fundamentally is a trial court faced with a plaintiff's motion for a judgment of strict foreclosure and a properly filed affidavit of debt pursuant to Practice Book 23-18A, making a reasonable accommodation to a self-represented party who was disputing the very debt claimed by the plaintiff to give him a week's time to say, essentially, come to me and show me why this is incorrect or why you believe this to be incorrect. And that self-represented party, the defendant in this case, simply failed to comply with the judge's invitation in that regard. That is the basis for this appeal. And the challenge that I understand Mr. Malick is making in this case is the trial court's, again, admission of the plaintiff's affidavit of debt, which of course, is commonplace in foreclosure actions. These are commonly filed, whether summary judgment is granted or whether there's a default scenario. And it's specifically provided for under the practice book that there is this mechanism. And then you have an added layer of, frankly, no good deed going unpunished, where the trial court, notwithstanding the fact that she could have entered a judgment of foreclosure on July 8th, gave an accommodation to Mr. Malick, which Mr. Malick is now complaining about, that gives rise to this appeal. None of the factual scenario, the procedural history here merits any overturning of what the trial court did here. Mr. Malick simply failed to present any viable evidence that contrasted with anything sought by the plaintiff in this case pursuant to a properly filed affidavit of debt after summary judgment was granted in its favor as to liability. And for that reason, I would respectfully request that this court affirm the judgment of the trial court. Obviously, I would welcome any questions that the court may have, but otherwise I would yield back the balance of my time. And thank you.
All right, seeing no questions. All right, Attorney Moss, you have 10 minutes.
Thank you. The court in Chenani resolved some ambiguity in the precedents regarding the standard of review. And this court in Chenani, 2017, Bank of America versus Chenani, held that the scope of review on precisely the question presented here is plenary in this on appeal, because it involves the ruling on implicit or otherwise, in this case anyway, the exclusion of evidence.
Attorney Moss, can I interject with a question? Let me give you a hypothetical. Let's assume a lender files an affidavit of debt and the defendant files some kind of affidavit that basically says, I disagree with the interest calculations, I disagree with the principal balance, and that's all that the affidavit says. Is that sufficient for you, in your view?
Yes. Well, the court in this case doesn't even need to reach that issue because there was a dispute here that was more than simply a denial. In Chinani, the court held that pleading in an answer insufficient knowledge or information with respect to an allegation of debt is insufficient to establish that there is a dispute. But in this case, the court doesn't need to reach the hypothetical Your Honor has posed, because you had specific elements of the debt that were contradicted by the defendant, elements of in the affidavit of debt that were contradicted. And I mentioned those being the property tax inspection and the tax escrow discrepancy, which was something over $4,000. And that alone, otherwise, if one were to go by the plaintiff's position, then you would really, in this case, what the judge was doing was attempting an evidentiary hearing where she is pitting the plaintiff's affidavit of debt against the plaintiff's evidence or submission. That's exactly a hearsay situation, because there's a dispute, and to follow the plaintiff's position in this case would require a full evidentiary hearing, a trial, but a lopsided trial in which one side's evidence is all hearsay and the other side has to produce competent evidence in opposition or to contradict that. And that it cannot be what our hearsay law, that just is not consistent with our precedents on hearsay. And the courts the cases uniformly hold that the affidavits are hearsay. So they cannot be accepted if there's any substantial dispute, any real dispute, any good faith dispute. And it's obvious from the record there's a good faith dispute.
All right, I see Judge Alexander has a question.
The July 12th memorandum that your client submitted, I'm looking specifically at page A52. None of those claimed disputes would have any bearing on the foreclosure, would it?
They might, but I have not made that claim on appeal. And again, it's not necessary to reach that question. There were, this is something that this sort of submission or these particular items are something that represent issues that have been in dispute between the parties, that have been litigated in federal court. And I'm not prepared to say they're viable, but in any event, I'm not claiming, and this on this appeal, that it is necessary to assign to those claims the status of being a dispute or of supporting the existence of a dispute, such as would render 2318A inapplicable, because there are other things that I pointed to that clearly do so. So there are counterclaims, there are offsets. To what extent are there offsets that haven't been litigated that might be evidence that might establish the existence of a dispute for purposes of 2318A defenses as to the debt? The court doesn't need to reach that, because there was a dispute as to tax escrow, dispute as to property inspection, and dispute as to interest rate, where you have a variable note. There's a question as to what rates applied in the affidavit of debt. It pointed to, I believe, a 5.39% interest rate, suggesting that it was carried as a fixed rate, possibly, certainly raising some uncertainty there. And it was challenged, disputed by the defendant, albeit not with his own calculation in particular, but he did challenge the interest rate, and he did come up with at least a rough number. And that's enough. That is enough to bar the admission of the affidavit. And how much of a burden is it really to the court or to a litigant here to bring in a live witness that can be cross-examined on these matters? Someone with personal knowledge, possibly, or without personal knowledge, and that can be then determined by the court as a matter of a factual finding without the use of hearsay. So to take the plaintiff's position would require a full-blown lopsided evidentiary hearing, and that certainly cannot be what our hearsay doctrine would or should allow. And 2318, the language is very simple. I believe the Chinani case is a very good discussion of what is required, and it would be good to compare this case to that. In that case, there was not only was there no clear denial in the pleadings as to the amount of debt, at least unlike in this case, where there is an absolute denial and a special defense that there's no monetary obligation. That was pleaded as well by the defendant. And also, at the hearing on the motion for judgment, there were specific items that were challenged. And I believe that's all that Chinani requires for the exclusion of the affidavit. Thank you.
All right. Thank you, counsel. All right. The court will take the matter under advisement and will stand in recess until 4 p.m. Thank you.